Any mention?
May I please, Your Lordship? I beg to mention item number 12, my lord.
Three weeks.
Please, Lordship. Lordship, I beg to mention item 13.
13.
I'm praying for 2 weeks time, Lordship.
2 weeks.
2 weeks, Lordship.
2 weeks. Definitely.
May I please, Your Lordship? Lordship, I beg to mention one unlisted matter. Lordship, the matter was listed yesterday, bill application number 55, 56 and 57 of 2026. Lordship, as per the last order, Lordship, the petitioner was give submission. If the charge sheet filed, they will withdraw the matter. The charge sheet had already been filed, my lord. So I pray I may allow to withdraw the matter with a liberty to file a fresh in the trial court, because charge sheet has already been filed.
Matter is not today.
Lordship, I beg to mention this matter may listed on 20th day after, my lord. Only for the withdrawal the
You
matter.
want to prepone the date?
Your
It
Lordship,
has already been fixed.
Lordship is fixed on 27th of this
27th,
month.
Lordship.
Lordship.
Okay, 20th.
20th. Lordship.
Just give the case number. Give it
Lordship,
to
I'll
her.
give to master. Oblige, my lord.
Lordship, just mention on joint request, Lordship.
Joint request.
Item number 14. For 2 weeks.
2 weeks.
Lordship.
2 weeks.
Hello, Blake. Your Lordship.
So item number 15, the joint request, Lordship.
15.
15, one last item, Lordship.
3 weeks.
Joint request.
Joint request, Lordship.
3 weeks.
Take your badge.
Supplementary list, item number 1.
litigation for continuation of delay, Your Lordship.
Oh, only for continuation of delay.
Yes, Lordship. Delay is 210 days, Lordship, for filing of appeal against judgment on order by the learned judge of the District Council Court, Your Lordship, in divorce case number 45 of 2015. Happened, Your Lordship, in this case, a series of events have transpired during the litigation of the divorce case. Ex parte was passed against the instant applicant, and then ex parte was recalled. Thereafter, the appeal judgment was passed in 25/7/2025. In connection to this matter, also, Your Lordship, maintenance was filed, whereby the jurisdiction and maintainability was challenged, which went up to the Supreme Court, Your Lordship.
Okay. Yes.
It's reported as AIR 1017, Supreme Court 2588, Your Lordship. This dealt with the jurisdiction of the District Council Courts, Your Lordship, regard to matters regarding tribals.
Okay.
So, Your Lordship, after during the course of litigation, there was change of counsels, Your Lordship, and then thereafter the impugn judgment was passed in 25/7/2025.
What is the subject matter of the
It's a divorce case on the grounds of cruelty. So challenging the maintainability of the very judgment with regard to jurisdiction, and the absence of the ingredients of cruelty, and amongst other grounds as well, Your Lordship.
But as far as maintainability is concerned, the Supreme Court has settled that matter.
This is in connection with the same parties, and with regard to
Same dispute.
this is maintenance, Your Lordship.
Of
But then the
maintenance.
parties are the same, and it states that
Okay, okay.
the District Council has no jurisdiction with regard to the parties, as one of the parties belongs to Pnat community and the other the Pasi community. Your Lordship. So after the
So the
passing-
matter was taken up by District Council Court,
District
Judge,
Council Court.
District Council Court,
Yes.
Shillong.
So, Your Lordship, what happened is
But you had participated in the proceedings?
initial proceedings, ex parte was passed, but then ex parte was recalled and she participated.
Okay.
Then judgment and order was passed in 25/7/2025. So change of counsel was there, Your Lordship. So the present counsel was engaged in February of 2026. Thereafter, but then even the record was not complete at that time, Your Lordship, because it remained with the previous counsel. So considering that certain events had transpired, even the case record was voluminous. So the applicant, she needed time to go through the records itself, and also to get the complete record from the previous counsels. That's why there's a delay, Your Lordship, in regard to the matter. It's well established also, Your Lordship, that with regard to continuation of delay, liberal approach must be adopted. So the subject matter can be adjudicated on the basis of merits, and also with regard to natural justice. Yes, this AIR 2024, Your Lordship, Supreme Court 4046. Lordship, at paragraph 22, Lordship. If negligence can be attributed to the appellant,
Just a moment.
necessarily the delay,
Para?
para 22, Lordship. negligence can
Just a moment. Yes.
If negligence can be attributed to the appellant, then necessarily the delay which has not been condoned by the tribunal and affirmed by the High Court deserves to be accepted. However, if no fault can be laid at the door of the appellant and cause shown is sufficient, then we are of the considered view that both the tribunal and High Court were in error in not adopting the liberal approach or justice-oriented approach to condone the delay. And Your Lordship, considering the facts and circumstances of the case, I pray that delay may be condoned so the subject matter can be adjudicated on merits, Your Lordship.
Please, Your Lordship. With regard to the issues set out by my friend, the trial court has been dealt with all those issues. As for the maintenance case, that is, it has no relevancy in this divorce case, Your Lordship. However, now I'll come to the condonation. For a delay to be condoned, there has to be a sufficient cause, which in this case, Your Lordship, there is none. Going through all the entire application of the applicant, there is nothing, there is no mention of any sufficient cause, except under at para 14, which para 14 is not, which is not a sufficient cause. However, it is merely an excuse. What reason had stated by the application was that she had just engaged a new counsel in the month of February 2026, Your Lordship. What happened? The decree and judgment was passed in the month of on 25th 7 2025, and there was a delay in even in applying for the certified copies, that is 1 month, and there was no explanation as to why there was a delay, and thereafter it was finally supplied to the appellant. Thereafter, instead, the appellant could have engaged anyone. There are thousands of lawyers here in Shillong. So, however, she was sitting idle for such a number of days, Your Lordship. So I pray that my submission is that the delay was gross and willful. So I pray that Your Lordship may be pleased to reject and dismiss the application filed by the petitioner, Your Lordship.
If I may, Your Lordship, even admitted by the respondent that there's a late application of certified copy.
Yeah.
There's maybe a miscommunication with the previous counsel as well with regard to the judgment, whether or not it's been passed or maybe miscommunication, and as such the litigant should not suffer, Your Lordship. Matter can be adjudicated in merits, Your Lordship.
See, what do you have any authorities on what constitute sufficient cause or what would not constitute sufficient?
As of now, no, Your Lordship. But
You should have. When you make a statement based on the averments in the petition that no sufficient cause has been shown, so you tell me what would constitute, or rather, what would not constitute sufficient cause.
another didn't be fixed so that I may bring
Could
authorities.
have come prepared. Matter could have been disposed of. Since you are opposing the application for condemnation, the applicant has maintained that merits of the matter has to be looked into. More often than not, courts are liberal as far as condemnation of delay is concerned, except if there's, like you rightly said, gross negligence. But that has to be pointed out. Just reading a paragraph from the petition would not suffice. Give me those authorities.
Lordship.
Can you do it by day after tomorrow?
It'll be 1 week, Your Lordship.
Heard the counsel for the parties. Kadi-kadi miss case. However, at the close of the argument, the learned counsel for the respondent has sought for some time to produce relevant authorities in support of his contention. Accordingly, as prayed for, this is matter after 1 week.
Item number 6.
May it please your lordship. My lord, this is the
Give me the
district selection matter, my lord, where my lord has directed the respondents to file the compilation of the marks obtained, and they have filed, and a copy was served to me also, my lord.
Yes.
And my lord, now the serious challenge to the locus of the petitioners have been come to question, my lord.
Yes.
My lord, my 2 points that before coming to reply to the locus, my lord, and it will be a very narrow, very brief submissions, my lord, to that. Just to recapitulate what did I submitted on the last day, my lord. I said the rules cannot be changed, and scaling down of the typing speed, my lord, and that is a changing of the rules, so that is not be allowed. Besides whether I have a locus or not, my lord, because that's one. The second part, my lord, I have challenged the biasness, my lord. Somewhere there is the allegation of biasness, the allegation of unfair practices, unfair means have been adopted, my lord, in order to facilitate some candidates. These are the 2 things that I have argued, my lord. And subsequently, my lord, then my lord has said, because they were raising the locus, because once I have participated, you have once participated, and securing a lesser mark than the people who got selected, then how does it prejudice to you? So that is a question that has come, my lord. Very true, my lord. That would be because, my lord, once you have participated in some recruitment process, my lord, you subsequently you found yourself not to be not successful. You cannot come back and challenge, my lord. That rule is there, my lord, but that rule is not absolute, my lord. Why is not absolute? Because participation means acceptance of the prescribed procedure, my lord. But it does not mean is an acceptance of illegality, my lord. So I have participated.
That is in, you see, that is with regard to subsequent events.
Yes, that's got a subsequent, my lord. Now here, my lord, why I was challenging also, besides if I am failing in 1 point, my lord, because now, my lord, even if I get selected or I don't get selected, my lord, or whether I am whether I qualify or I don't qualify, my lord, if I am going to raise something which illegal means has happened, if there is an allegation that something illegal means has happened, my lord, then, my lord, that absolute estoppel will not operate against me. And here I will demonstrate only 1 point, my lord. Why do I keep on saying that there was an unfair means has happened to facilitate and accommodate some selected people, my lord. Number 1 thing is, my lord, first of all, the answer scripts, my lord, or the corrections was done, my lord, in pencil. In pencil. And what justification they gave? They say that it is easy to if they make a mistake, then it's easy to erase. So there won't be interpolation, or there won't be white ink and etc. and etc. my lord. So this is what they say. But at the same time, white using pencil can also mean easy to alter. It can also mean, my lord, it goes 2 ways. It's not only in one convenience way, it can go two ways, my lord. So the justification that the chairman is giving, the justification that no, it's easier to correct the mistake, my lord. That itself, it's cast with doubt. My lord. Why cast with doubt? Subsequently, what is happening? What had happened, my lord, is before the final notification, the result was declared. Before the final result was declared, my lord, there was already a result going around the social media, my lord. And surprisingly, my lord, not all of them, some of the names who were purportedly to be selected in social media, my lord, when the final list has come, their name also appeared there.
You mean what has appeared in social media and what is the the eventual result tallies?
Tallies, not for all the candidates. For some of the candidates, it tallies, my lord. Now I put a question to myself, my lord. The recruitment process is of secrecy, my lord. Who has scored how much mark? Only the examiners and the authorities would, the concerned authorities would know. I won't know Mr. A appeared. I will know Mr. C appeared. I will not know Mr. A or C is getting selected, my lord. But the inside people will definitely know. So how come the social media, which they themselves have admitted that it is a fake result, how would somebody know a fake result and also identify the candidate who sat and who was getting selected? So even if I fail in the other part, my lord, the locus, my lord, this aspect needs to be examined because, my lord, the illegality can be brought in the recruitment process, my lord. It can be brought by anyone. More so here, the petitioners were the participants. So therefore, my lord, that is a reason I say that even if it is an unsuccessful candidates can bring illegalities committed, my lord, to the notice of the court. Not necessary. So therefore, in this event, my lord, I will not be hit by locus. I will not hit by whether, since you have failed in you have scored less mark, it does not prejudice to you, my lord. It does not prejudice. It may not prejudice to me directly, but it is an insult and it's an injury to all the job seekers. Now this allegation is even expanding the number of people who are going to get injured. That means that 900 people who have sat for the interview, they have all been injured because this has from day one has been channelized to favor some favorite candidate. Number one, your favorite candidate did not qualify in your typing speed. Therefore, you have scaled down. You go for corrections and answer scripts with a pencil so that you may give a grace mark or you may add, qualify by force, my lord. Thirdly, you give a justification that no pencil is used, is much convenient to use, convenient to do cheating. And fourthly, my lord, then finally the result comes in the social media and you very quickly disown that result, saying that no, that is not our result, it's a fake result. But then on the next day, you've declared a main result, and when you compare these two lists, some of the candidates' name appeared in the main list, my lord. So this incidents, this change of circumstances, the change of events, my lord, actually calls for further inquiry. My lord, why do we call, my lords, extraordinary? Why do we call, my lord? Extraordinary jurisdiction, why do we call, my lord? Extraordinary because once these kind of things are brought to my lord may exercise the extraordinary power to go in depth and look into what has really have transpired, because the fairness is the hallmark in a recruitment process, and there can be nothing bigger than that, my lord. I get my job, I get not job, my lord. It's not a primary matter at all, my lord. But the fairness that I am advocating before my lord, for my clients, my lord, and for the job seekers of the 900 people, my lord, whether they are here or not, my lord, this needs to be taken into considerations, my lord. So, my lord, facts of the case and all this I've submitted. This is the third round where we are actually arguing, my lord. So today, my lord, with these submissions, my lord, I would rest my arguments, my lord, and would pray, my lord, let, if my lord may pass the necessary orders, my lord, even to the extent, my lord, if my lord is convinced and find that there's some illegalities must have actually taken place, my lord, make cause for inquiry also, at the same time setting aside that the selection list, my lord. Well, that is all to say. There's a judgment, my lord. I'll be submitting little later, my lord. It's a 2019-20 SEC 17. This talks about the distinction between a candidate challenging a known selection procedure. Like, I've opened up my eyes, everything I'm challenging knowingly. For this kind of candidate, it's barred. But if some kinds of candidates would be as such that subsequently you find some illegalities, my lord, that constitutionally the selection itself is constitutionally wrong or against the procedure, my lord, then for that kind of person, my lord, that rules is not absolute. It is an exemption, my lord. So that judgment I'll just submit to the bench.
Just give me the citation.
Is to, my lord, let me just confirm this, my lord. Let's confirm this citation, but this is the 2019-20 SEC 17. I don't want to give a wrong site. Sometimes numbers.
You're not sure of yourself also.
My lord, this is sure, but I want to be 100% sure. So I'll give it. I'll give it in the course of the day itself, my lord.
Okay.
Yeah, my lord, that is all.
Any private respondents? Yeah. No.
Private respondents are there, my lord. They're represented by.
This is your lordship. Lordship, in fact, this matter has been heard, lordship. If lordship kindly have the order dated 16/4/26. Where is that order? 16/4/26. We file this if relevant.
$16.
16/4/2026, your lordship. See now from the mobile. In pursuance to that order, your lordship, and affidavit to bring on records, your lordship, the comparative
Okay, you have filed an affidavit in this regard?
lordship, yes. Lordship, kindly have the affidavit at paragraph 5. That is the affidavit filed on 1/6/26, your lordship. Lordship, kindly have at page 3, paragraph 5. That is submitted that in such case the writ petitioner mandate to only the qualifying typing test.
Just a moment.
Lordship.
Para?
Para 5, Lordship. Lordship, kindly see their lead petitioner.
Yes.
The lead petitioner, your lordship.
Yes.
In the typing test, she got 38. And in the written test, 195, Your Lordship. So she failed in the written test, Your Lordship, because the written test, Your Lordship, the cut off mark is 200. 200. Then Lordship kindly see serial number 2. Hyacinthic case Sangma, Your Lordship, 26. After the mark has been scaled down, Your Lordship, we got 26, Your Lordship. That is the cut off mark. And in the written test, Your Lordship, 119. So he also failed, Your Lordship. Then Lordship kindly turn to page 4.
Yes.
Page 4, Your Lordship, kindly see number 3, Your Lordship, fail. They did not qualify.
All these still 12, they all fail.
All fail, Your Lordship. Then Lordship, kindly see the mark obtained by the selected candidates. They cross the cut off mark in the typing as well as in the written test, Your Lordship.
Yes.
Lordship. So my humble and respectful submission, Your Lordship. First, the writ petitioner, Your Lordship, being unsuccessful, Your Lordship, in the selection process, they cannot question, Your Lordship, the selection and appointment of the successful candidate, Your Lordship. In this connection, Your Lordship, I would like to rely in the judgment of, where is this? I just clear. Lordship, if Lordship kindly have paragraph 14 of that judgment.
14.
Para 14, Your Lordship, yes. 14, 15, 16, 18, Your Lordship. If I may read para 14, Your Lordship.
Yes. Just a moment, let me get this citation first.
Lordship,
This is 2007.
this is 2007 age SCC 644, Your Lordship. Tribedi Himanshu Kanchia Bhai versus Ahmedabad Municipal Corporation and others, Your Lordship.
Yes.
If Lordship kindly have a para 14, it may be mentioned as noted here earlier that the oral interview was conducted by a 5-member interview committee consisting of so and so, so and so, so and so and so. So, Ahmedabad, who are all respected persons of the society. The 5-member committee, which consists of eminent persons of the society, would not have allowed the appellant, who is a technique, to appear before them without first satisfying themselves that the appellant had possessed 10 years administrative experience. If the administrative experience shown in the application form could not be treated as a sufficient compliance with the requirement as to 10 years experience on the administrative side, the interview committee, being an expert committee, could have rejected the candidature of the appellant on the ground that he did not possess the requisite administrative experience for appointment to the post of assistant manager in the corporation. That apart, on the question of the administrative experience of the appellant, who was working an X-ray technician, no objection was raised either by the examination committee, which conducted the written examination, or by the interview board, which conducted the oral interview. Even the candidate, namely writ petitioner respondent number 2 and 3, did not raise any objection by making a prayer either before the examination committee or before the interview board that the appellant lacked the requested administrative experience for selection to the post in question. After scrutinizing and considering the application form of all the candidates, they were directed to appear in the written test, and after those who were found to have passed the written test were directed to appear before the interview board for an oral interview. From the record, it appears that in the past, many persons who were holding technical posts were promoted to administrative posts and subsequently have been further promoted. That apart, the corporation at the time of inviting application for appointment to the post in question had never stated that the person of technical cadre should not apply. On the contrary, the circular details stated that the candidate of all the departments were qualified to apply on fulfilling the requirement laid down in the circular. The writ petition respondent 2 cannot be permitted to raise the objection that the appellant could not have been considered for appointment, his being a technical hand without any administrative experience after the appellant was selected along with the other selected candidate. It was open to the respondent number 2 and 3 to raise such an objection at the initial stage, either in the written examination or at the time of oral interview. Such objection was raised for the first time by the respondent number 2 and 3 after the appellant successfully completed 4 months in his capacity as an assistant manager, his promoted post in the corporation. Therefore, it appears from the judgment of the High Court that the High Court has quashed the appointment of the appellant only through the corporation had appointed 7 other candidates holding such rank. Therefore, we are unable to agree with the High Court that the administrative experience enlisted by the appellant in his application form duly endorsed by the medical officer could not be considered as an administrative experience over 10 years, and therefore the appointment of the appellant should be cancelled. In any view of the matter, it is not for the court to find out whether a candidate from the technical side was having administrative experience of 10 years when he applied for the post of assistant manager, as we find that a manual of the corporation clearly stated that it was the sole discretion of the municipal commissioner to consider as to which post was technical or administrative. In our view, the High Court has failed to appreciate that the corporation, being the employer, is the best judge to decide whether the appellant had discharged the responsibility on the administrative side, and once the corporation came to a finding that the appellant had discharged not only the duties of an X-ray technician but performed clerical administrative work, particularly in view of the admitted fact that since so-and-so no post of clerk was created in so-and-so hospital, the High Court was not justified in concluding that the appellant did not possess. As noted earlier, para 16, respondent number 2 had filed the writ petition before the High Court challenging the appointment of the appellant were themselves unsuccessful in the examination, Your Lordship. Even though they claimed that they had passed the written examination but failed in the interview. Here, Your Lordship, they did not qualify, they did not pass, Your Lordship, either the speed, the typing speed, as well as the personal interview. Before the and did not figure in the merit list. In our view, it was not open to them to challenge the selection list and appointment of the appellant before the High Court. Then, Lordship, kindly see para 18. Accordingly, we are of the view that the High Court was neither justified in interfering with the appointment of the appellant by holding that he did not possess the requisite administrative experience of 10 years while working as an X-ray technician, nor it was open to the High Court to entertain the petition challenging the appointment of the appellant and other selected candidates at the instance of the unsuccessful candidates. So, Lordship, exactly the case here, Lordship. The Lordship, the writ petitioner did not qualify in the typing speed test as well as in the written examination, Your Lordship. There is a Lordship, if Lordship for the time being, if Lordship kindly have a page 38, page 26, Your Lordship, of the writ petition. Lordship, page 38, Your Lordship, not 26, Your Lordship, 38 of the writ petition. That is the RTI information, Your Lordship, addressed to the one person by the name of Srimati Aksha Dishira. Lordship, kindly see the reply at question number 3 and 4. Lordship, kindly see. Please inform me the cut of mark for general ST, SC and physical handicap in above case. Cut of mark for general SC and ST is 200. Physical handicap is. Please inform me cut of mark minimum speed for typing test above exam prescribed fitting to due to insufficient number of candidate. Cut of mark was settled at 26. Your Lordship. One of the candidate, Your Lordship, the writ petition also he obtained 26. Your Lordship. That is serial number 2 of the comparative charge, Your Lordship.
Yes.
So, Your Lordship, the locus, Your Lordship, of the petitioner is doubtful in as much as, Your Lordship, from their record, Your Lordship, that is the comparative statement filed by the filed by the state, Your Lordship, in the affidavit, Your Lordship, of 1/6/2026, Your Lordship, the petitioners, all the petitioners, Your Lordship, were not successful, Your Lordship, in the typing speed as well as in the interest in the personal in the written test. So as such, Your Lordship, being the unsuccessful candidate, Your Lordship, they cannot question the selection as well as the appointment of the private respondent. This is my first submission, Your Lordship. Then the second submission, Your Lordship, advanced, but that there was a result, Your Lordship, in the social media. If Lordship kindly have paragraph Lordship kindly have our affidavit, Your Lordship, at paragraph 5, at paragraph 7, at page 5, Your Lordship. Lordship, that we have denied, Your Lordship. This is a fake and falsely fabricated, Your Lordship, done by some people who are trying to derail the selection process, Your Lordship.
Yes, sir.
Lordship, kindly have our affidavit, paragraph 7, at page 5, Your Lordship. Page 5, Your Lordship, and paragraph 7, Your Lordship.
Page 5.
Page 5, our affidavit, that is the affidavit filed on Lordship, there's no date.
This was June.
Filed on 17 November 2021.
17/11/21, Your Lordship. There is no date, and date has not been mentioned, Your Lordship, in my Lordship. This is the affidavit filed on November 21, Your Lordship. Affidavit filed by the respondent number 123, Your Lordship.
Seventeen.
17/11, Your Lordship, 21, Your Lordship.
Para.
Lordship, kindly have para 7, Your Lordship, at page 5, Your Lordship.
Yes.
Lordship, then we have denied, Your Lordship. We say that this was a fake and fabricated, Your Lordship, done by some people, Your Lordship, to derail the selection process. And to that effect, Your Lordship, we have also filed the FIR with William Nakar at William Nakar Police Station. And Lordship, there was a case registered, that is William Nakar PS case number 2608 of 2021, Your Lordship, under section 469 500 IPC, Your Lordship.
What is the status of this case?
Lordship, that Lordship, I'm not.
What is?
Lordship, I have not sought instructions so far the status of this investigation, Your Lordship. But the fact remains, Your Lordship, that FIR has been lodged, Your Lordship. Has been lodged, Your Lordship. Whatever the result, Your Lordship, had been published on the WhatsApp, that was a fake and fabricated result, Your Lordship. The real result, Your Lordship, was declared on 31st August 2028, Your Lordship. Lordship, kindly have a para 9 of the affidavit, Your Lordship. Para 9, Your Lordship, at page 7, Your Lordship. Yes. Somewhere in the middle, Your Lordship.
Yes.
Lordship, 1, 2, 3, 4, 5, 6, 7. Lordship, 7 sentence from the bottom of that para 9, Your Lordship. The answering respondent.
Yes.
Most humbly submit that the actual result was declared on 31/8/2021 by notification number so duly signed and with the official seal by the member secretary district selection committee, which was true and genuine. The same was uploaded on the official website of the district shared through the official Facebook page of the district, and also put up on all the notice board of the office. Then, Lordship, another submission, Your Lordship, from the pleading in the writ petition, Your Lordship, it appears, Your Lordship, that the writ petitioner were fully aware, Your Lordship, of the criteria, Your Lordship, of the selection process, and having failed, and in spite of the fact that they knew, Your Lordship, the procedure, the criteria laid down, still they took part, Your Lordship, in the selection process. They are stopped, Your Lordship. In my humble and respectful submission, Your Lordship, they are, after having failed, Your Lordship, in the selection process, they are stopped from questioning, Your Lordship, the selection process. This is my humble and respectful submission, Your Lordship. Lordship, I need not burden Your Lordship with the decision, Your Lordship. In fact, Your Lordship is aware, Your Lordship. once you took part in the selection process, Your Lordship, without murmur, Your Lordship, and when the result is not palatable, not favorable, you cannot question, Your Lordship. Highly apply, Your Lordship.
Yes.
I'm appearing on behalf of respondent 4 to 27, 29 to 37.
Yeah.
Your Lordship, first and foremost,
Yeah, for respondent. 4. 4.
4 to 27, Your Lordship.
4 to 27.
29 to 57.
Okay. What about 28?
28, I'm not there, Your Lordship.
Who's appearing for 28? Is there any 28 here?
There is, Your Lordship, but
There's an order passed earlier.
Ex parte?
It appears, Your Lordship, that she was a disqualified candidate. Disqualified candidate, Your Lordship.
No. Any order to drop her?
Yes, there is an order, my lord.
Okay, okay. Since you say there is an order, then we'll take it that there is an
My lord,
order.
I'll just point out that I have the order sheet.
Okay, okay. You can check.
Let us stop.
You can leisurely check that. Yes, please.
Your Lordship, first and foremost, I have all the required qualifications, Your Lordship. The typing speed test, which they have contended that there was alteration and relaxation. That test, Your Lordship, they participated as well. Now, Your Lordship, if you look at the typing speed test, it was conducted on 18/2/2021 to 4/3/2021. The results was on 5/3/2021.
Yes.
Now, Your Lordship, I was successful in that typing speed test as well as now, Your Lordship, even assuming without admitting there was a relaxation or some kind of alteration, that was benefited not only by me but by them as well, which they were silent, they never protest, Your Lordship. Now, the written test was on 24/4/2021, Your Lordship, after more than a month from the typing speed test, Your Lordship. 24/4/2021, Your Lordship.
Written test?
Yes, Your Lordship. Now, till then, Your Lordship, they were
No,
silent.
written test is contingent to the typing speed.
Yes, Your Lordship. The typing speed test was the initial stage, Your
So
Lordship.
Once the type, they'll
once you
have to qualify
then,
for the
then
typing,
you
Your
qualify
Lordship.
for the written.
And then for the written, Your
But
Lordship.
they have not qualified.
They have not qualified in both, Your Lordship.
When was written test conducted?
4/4/2021, Your Lordship.
Okay.
Now, Your Lordship, it was only until the coming of the results, Your Lordship. Now, the entire selection process could not be derailed on the ground that they were unhappy or not satisfied because they did not get through, Your Lordship. Now, I've already joined my respective posts, Your Lordship, since 2021. We've all joined, Your Lordship. That is my information.
Yes.
This,
Yes, anything, Mr. Yogin, you want to reply?
my lords, the citations that I was replying to, my lord, is or referring to is this. I've got the citations here. Because, my lord, my argument has moved ahead, my lord. Ahead and rather sticking to whether I am stopped or not stopped, my lord. I've moved ahead. A typing speed I have qualified, my lord. Needless to say also, but the thing is that whether I was qualified or not qualified, whether it has prejudice to me or not prejudice to me, my lord, I've move ahead with that arguments, my lord. So they are replying to me. They got stuck in replying to me in that order, but I've moved ahead. Now, how do I move ahead, my lord? This kind of look at citation of 2019-20 SEC, paragraph 15, my lord. That is a preliminary issues, whether I'm stopped or not, my lord. This is the answer. paragraph 15, may I read, my lord?
Yes.
Thereafter, I'll show some points, my lord. Paragraph 15, furthermore, before beginning analysis of the legal issues involved, it is necessary to first address the preliminary issues. The maintainability of the very challenge by the appellant has been questioned on the ground that she, having partaken in the selection process, cannot later challenge it due to mere failure in selection. The counsel for the respondents relied upon a catena of decisions of this court to substantiate his objection. 16. It is well settled that the principle of estoppel prevents a candidate from challenging the selection process after having failed in its it is as iterated by this court in a plethora of judgment, including Manish Kumar, so and so, so and so. Now let us go to paragraph 17, my lord. However, my lord, there is an exemption.
Yes.
However, we must differentiate. My lord has got that, paragraph
Yes.
17.
Yes.
However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct, and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he or she participates in the selection process. I have participated in the selection process. I am saying that the selection ought to have been fair manner because it's sacrosanct. Why? Because it touches Article 16. Article 16, fair opportunity in public employment, my lord. Now, my lords, let us come back to my writ petition. Page 89, my lord. Page 89 of my writ petition, my lord.
I think you have referred to this page.
Yeah, no, not today. I did not refer my lord. I was waiting for the rejoinder, my lord. So, page 89, my lord.
Oh, 89.
Yes, my lord. Now, my lord has heard the learned senior counsel saying that this is a fake result. Page
Yes,
18,
this 89.
yes, page 89 is a fake result, my lord. This is what they have admitted also. And against this circulation of this, there's an FIR also. And they don't know the status of the FIR now. So the date is 27 August 2021. So let us assume that this is a fact. Now, the final result, the admitted result, is at page 92.
Yes.
Page 92, and that is the result date is 31st August 2021, my lord.
Yes.
27, 28, 29, 30. 3 days. Immediately after 3 days.
Yes.
Now, my lord, we can have a look at page 89, serial number 3, my lord. Page 89, serial number 3. Srimati Balsa Ritheme Di Momin.
Para 3.
Serial number 3. Balsa Ritheme Momin, my lord.
You are
And
referring
my
to
lord,
page 89.
yes, page 89. I just doing a little bit comparative, my lord.
Okay. Yes.
Page 89.
Balsa, yes.
Balsa. Now, my lord, at page 92, serial number 7, my lord. Balsa.
Yes.
Now again, my lord, we'll see at page 89, serial number 14, Shri Dromi K. Sangma.
Yes.
And page 92, serial number 40, serial number sorry, Chime M. Sangma 15, my lord. 15 of page 89, my lord.
Yes.
And then serial number 40 of page 92, Chime Sangma. And again, my lord, serial number 89 of serial number 20 of page 89.
Yes.
Compare with serial number
9.
9, my lord. Jenar Marak 20, sorry, 20 of 89.
Right there by the scale.
Gerard Marak, my lord.
Yes.
So I'm quite, my lord, so and so forth, my lord. If you compare this one, the fake result, the successful names, successful candidate's name appear here, even in the result, final result. How is that possible, my lord? It's not possible, my lord.
But even, you see, Mr. even at this stage,
Yes, my lord.
since you have been disqualified in the early stages of the selection, not disqualified, but you have not qualified rather,
I have not qualified, my lord.
since you have not, got through the typing speed test.
Yes, yes.
So these are the results of those who have firstly, qualified through the typing speed,
Yes,
then the written,
yes,
and then finally the personal.
yes, yes, my
So
lord.
that's the. But in all those stages, you have been left out.
No. In the typing speed, my lord, I have qualified. Oh, that's just for the correction, my lord. In the typing speed, I've been qualified, my lord. If you look at their own compilation of.
But if you qualified typing speed, then for written.
In the written,
Written
I
to
admit, as per their documents, my lord, I have not qualified in the written.
But
I admit,
okay.
I
Yeah.
admit, in the written, I have not qualified, my
Okay.
lord. But my question, that's why I said, my lord, I have gone ahead with my one step ahead with my argument by saying that, my lord, there is illegality. There was no fairness in the selection process, my lord, and therefore, my lord, they cannot say I am stopped because I did not qualify. The Supreme Court judgment of 2019, my lord, gave an exemption under what circumstances if there is a challenge to illegality. How do I challenge to this illegality? I've pointed out illustration, I've given an illustration, the result. Fake result comes 3 days before the final result. Maximum of the candidates who got selected names are there. My lord. So, my lord, loss of trading is underneath loss of trading has happened, needless to say, my lord. So therefore, my
But
lord,
that, you see, as far as that page 89 is concerned,
my lord,
that would be apparent only after the criminal case is, decided. Then we'll know whether it's, fake, manipulated, or it's correct. They may say it is not. It's the official result.
then in that event, my lord, then my writ petition cannot be disposed of. Then we'll have to wait for the outcome of the. Otherwise, then there'll be a new course of action, my lord.
True.
So then in that event, my lord, if my
That
lord,
aspect of, yes, Mr. Shula, I think that aspect of the matter has to be.
Lordship.
That aspect of the matter has to be considered.
yes,
You see, if the first result, which you say is a fake result,
Fake, your lordship.
is under scrutiny by a criminal court.
And it was
Now it's undergoing trial, so to say. Now we don't know the decision of the trial court, whether it has been decided or not. So in the event the trial court, the criminal court says that this result are correct, then it will have an impact as far as your page 92, the subsequent result is concerned. If it is found that yes, it is not, it is fake, somebody would be prosecuted for that, then that subsequent result will stand.
but lordship here, your lordship, be that as me, your lordship.
That is why now the consideration would be in such a scenario whether it would affect the petitioner or not.
Lordship, kindly see, in my humble arrestable for submission, your lordship, it will not affect the petitioner in view of the fact that, your lordship, it is the admitted fact, your lordship, the petitioner also, they were aware that the Court of Mark, so far the written examination is concerned is 200, your lordship. Admittedly, your lordship, they did not qualify that written examination, your lordship. If that, your lordship, I forgot to cite a constitutional bench judgment, your lordship, that is, if lordship kindly. Lordship, kindly have that 2017 4 SCC 357, your lordship. This is by a 3-judge bench, your lordship. If lordship kindly have para 15 of that judgment. Para 15, your lordship. In Manish Kumar Sahi versus State of Bihar, the same principle was reiterated in the following observation. Lordship, kindly have para 15 of that judgment. This is a 3-judge bench decision, Your Lordship. We also agree, Lordship has got done.
Yes, yes.
We also agree with the High Court that after taking part in the process of selection, knowing fully well that more than 19% mark have been earmarked for BIBA boss tests, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the petitioner name had appeared in this merit list, he would not have been dream of challenging the selection process. Same here, Your Lordship.
Actually, that of course.
Lordship, yes.
If he's meritorious, he won't challenge.
Lordship, yes.
Because he's
Lordship, can you see, Your Lordship, in the written test, you did not qualify. As per the code of mark, you did not qualify, Your Lordship. So where is your locus, Your Lordship? Where is the locus of the petition to question, to say otherwise the selection process, Your Lordship? When you have not qualified. If you have qualified, Your Lordship, that is a different thing, Your Lordship. But here, Your Lordship, admittedly, they have not qualified, Your Lordship.
You see, Mr. Yubin, perhaps what he says, I'm not saying, you see, this court would take that into account. But you see, the written test, you take it as a standalone.
Yes.
Now what happened is, qualifying marks at 200, you have secured 195, and so on and so forth. So even there, you are out of contention, irrespective of the fact that you have qualified for the typing speed.
Yes.
See, so whether the final outcome is taking as a cumulative marks of written and typing speed or not.
That is true, my lord. What I'm advocating here, my lord, I'm not saying that whoever has been qualified, my lord, legally, my lord, should be removed and should be given a job to me, my lord. I'm not on the aspect of prejudicial effect to me, my lord. What I'm saying is it has injured all of us, my lord, the petitioners who were before my lord also. Why? Because there was no fairness. And if there was no fairness, if there was purportedly illegality, then I cannot be stopped. This is what my contention was, my lord. So, so yes.
You see, now again, if you go into the coming back to the same thing, as far as your contention on fairness is concerned,
my lord,
it is confined only to the aspect of the typing test, not the written test.
No, the typing test, because my lord, this has a cumulative effect.
It has.
Why? Because the person who got selected, which I've just pointed out few names, my lord, are the beneficial of right from step 1. And my lord, I've also pointed out that the justification was given at page the justification given by at page 93, my lord, 93 by the secretary, my lord, of the DPC, my lord. He says at page 93, he says that we are using a pencil.
Right, of course,
we are using a pencil. So why do you use a pencil? That the question comes. So this has to be conjointly, the entire circumstances needs to be conjointly looked, chain one after another.
See, but whatever the case may be, as far as typing speed is concerned,
yes,
that is gauged by a machine, computer, whatever. It cannot be said that the speed that is the result that is taken out from there can be manipulated or can be noted down in pencil and rub off and another result entered. I don't think
it cannot be. It cannot be, my lord. It cannot be. That I bow down to what my lord is saying. But subsequently, what about the OMR sheet or result? There was an RTI recently.
That OMR would be confined only to the written test aspect.
Yeah, my lord. So now, because you will have to look from every step, my lord.
See, now are you challenging the result of the written test then?
My lord, I am challenging the entire selection process. I am challenging the entire selection process because it is marred by illegality.
True, but your argument has to be broken down in certain sections.
Yes.
See, first the typing.
Yes.
How you are aggrieved by that,
yes,
the outcome of the typing speed test result, and then you go on to the written test and how the result not being favorable to you was the outcome of a manipulation, so on and so forth. That you have not placed in your argument.
My lord, my argument was on twofold. The first fold was that you cannot change the rule of the game, typing speed. The second was that there is an unfairness. That's what I pleaded also in my petition, my lord. There was an unfairness. There's somewhere illegality to favor some favorite candidates. So that's what I started demonstrating, my lord, why I cannot be thrown away at this stage until and unless I show to my lords what is the sequence of events that happened, and which has given a cast of doubt in my mind, my lord. That is what I've pointed out, my lord. So, my lord,
I think
regarding respondent number 28, my lord, that my lord was asking, that by order dated, my lord, 27/09/2023, it was this particular petitioner was a strike off, my lord.
Yeah.
Yes. 27/09, my lord.
2023.
2023, my lord.
Respondent numbers 28.
28, my lord.
Name has been struck off, my lord.
Okay. So about the parties,
Lordship.
you filed your argument.
Lordship. In fact, your lordship, so far that contention of my friend that correction by a pencil, lordship has authored a judgment on that issue, your lordship. I cannot recollect, your lordship, the name, your lordship. It is case from conducted by the Meghalaya Public Service Commission, your lordship. They went to appeal that also have been upheld, your lordship. I'll try to find out.
You said that authority.
Lordship, I'll find out that judgment also, your lordship.
Heard learned counsel of the parties. Argument is concluded. On preamate, let written argument be filed within the next date fix. This is not after 2 weeks.
Apply.
Item number 7.
What do we do with the rest of the matters?
Lordship, kindly have, Lordship, I have some matter also with Mr. Yubin, your Lordship. That is item number 10 and 11, your Lordship. Matter next, if
Let's
Lordship.
take it first week, my lord. First week of September.
Lordship, yes. Item number 10 and 11, your Lordship.
2 weeks. 10, 11, 2 weeks.
What do you do?
Item 7, my lord, there is some urgency, my lord.
7.
7.
Next week, then.
1 week.
1 week, your Lordship, yes.
If you think that convenient your lordship in this week, my
Oh,
lord.
this is that OBC.
OBC, my lord.
1 week.
1 week. Highly apply, your Lordship.
Item A
Yes.
taken up on any other day.
This is also old matter. MIDC is to respond, isn't it?
No, my lord, the director has to respond.
Oh, director.
I'm the present
director.
incumbent. Yes. Second half, I will also have some difficulty.
1 week.
My lord.
Item number 9 as well, your lordship.
2 weeks. You are then item. It's also old matter.
Item number 9, your lordship.
Should we take it up after 2 weeks or 1 week?
2 weeks will do. 2 weeks.
You say you're the petitioner. 2 weeks.
Much obliged.
You are there, ma'am?
I am in number 8, your lordship. Or respondent number
Okay,
3.
that will be taken up after 1 week.